Hello, my name is Emily Hendrickson, and this is my Week 7 discussion. Today we are going to be examining procedural concerns and their broader implications in the U.S. judicial system. So first, let's go over some primary procedural concerns. So the first one we are going to go over is case backlogs. Second will be lengthy delays and case processing times. Third is going to be some constitutional concerns, and then fourthly, we are going to look at the impact on the participants in the justice system. So first is case backlogs. Courts at all levels, particularly federal district courts and state courts, face significant backlogs of both civil and criminal cases. According to the U.S. Federal Judicial Caseload Statistics of 2024, combined filings in the U.S. district courts for civil cases and criminal defendants increased by nearly 61,000, or 17%, to approximately 414,000. Although terminations of cases fell by 10%, the filings ultimately exceeded the terminations, meaning the total for pending civil cases and criminal defendants rose by a total of 6% to equal 746,577. Next is lengthy delays in case processing times. In federal court, it is pretty routine to have a case set for trial within 12 to 18 months of filing. In state courts, however, the amount of time it takes to get to trial can vary widely depending on the type of court, which state, and which county. For a variety of systematic reasons such as case complexity, court backlogs, attorney and judge availability, volume of evidence, especially when it concerns digital or forensic, willingness to settle, etc., most cases in state courts take far longer to get to trial than cases in federal courts, often pushing the average of completion to 2 years or more. Next is constitutional concerns. For criminal defendants, the Sixth Amendment guarantees the right to a speedy trial. Case backlogs can lead to extended pretrial incarceration for those unable to afford bail and can hamper a defendant's ability to prepare proper defenses, as witnesses may become unavailable or their memories will fade. The Fifth and 14th Amendments include a due process clause, which guarantees fair judicial proceedings. Extensive delays in court proceedings can result in a deprivation of justice by forcing individuals, especially those who cannot afford extended litigation, to accept settlements or plea deals. And lastly is the impact on justice system participants. Litigants, also known as the individuals who use the justice system, are impacted by case backlogs via increased costs paid for representation and higher levels of frustration, which can lead to a resentment towards the court system itself. Legal professionals, including lawyers and judges, are also impacted by case backlogs through increased personal caseloads, which exacerbate work stress and cause the judicial system to focus on slam dunk cases. Israel 1996 writes that an increase in caseloads are said to force prosecutors to restrict prosecutions for misdemeanors and nonviolent felonies in order to focus on cases in which there is such a high probability of establishing guilt that the case can be categorized as a slam dunk or open and shut case. So you may ask, why are these concerns significant? So we'll be focusing on the erosion of public trust towards the judicial system and the impact on the administration of justice itself. Public trust is a fundamental component of the court system because in reality, the courts serve the public, so it is integral to the legal system for the public to trust the courts. Legal scholars have expressed concerns that continued systematic delays in the administration of justice undermines public trust and confidence in the judiciary's ability to function effectively by closing cases. So now we're going to look at some substantive agendas behind procedural concerns. Here's a question. Do critics of the court have substantive agendas underlying their procedural critiques? In short, yes. There is often a link between substantive agendas and procedural critiques, as procedural rules affect the outcomes of cases. By arguing about the procedural structure of the judiciary or process of law, substantive agendas held by critics of the court can often be masked. Even if it is not explicitly voiced, as it is often masked, The ultimate goal of a procedural critique might be to advocate for structural reforms that would ultimately change the ideological balance and systematic procedures of the court itself. Similar to the last slide, the question, are there possibly deeper disagreements over legal interpretations, rulings, or judicial philosophies at play, can be posed. Without a doubt, there are unseen reasonings surrounding the arguments for procedural reforms, stemming from court critics' personal philosophies, beliefs, and values. As with most political or controversial topics, critics often mask the wishes or true feelings of the arguer. For example, critics of the judiciary in its current state may highlight vague judicial interpretations, controversial rulings, or adverse judicial philosophies in order to argue their beliefs and agenda as the rightful ones that should be applied to the court system. And then these are my 3 references. Thank you.